Good afternoon. It's an honor to address such a distinguished audience on the occasion of the 96th anniversary of the Metz Yegerno, and to discuss an unprecedented and historic case known as the Hairabedian Truth Trial on the Armenian Genocide. Before getting into the details of the legal process, I want to begin by sharing with you a couple of personal details. First, as you might notice from my name, I am half Armenian on my mother's side and half Spanish on my father's side. I would also like to tell you a personal memory from my youth. In 1993, I went with my family on a trip to today's Turkey to find the house of my maternal great-grandparents. We were searching in Tomarza, where they used to live when at one time Ottoman soldiers killed my family, raped women, and stole the property. I will never forget one image, that of the Armenian church where my ancestors used to pray in Old Tomarza. That place had been turned into an ugly and grey deposit of charcoal and firewood. I was 12 years old, and I felt a huge anger in my chest. The feeling of deprivation, injustice, and pain I felt at that time has stayed with me throughout my life. But something has happened recently, which helps relieve that pain a little. On April 1st of this year, the Federal Court of Argentina made a legal ruling that, and I quote, "The Turkish state committed the crime of genocide at the expense of the Armenian people in the period between 1915 and 1923. The ruling is very significant. First, because it came about as a part of the official Argentinian law, and second, because it also relates to international law." I'm going to speak something about the background of the case. This case was initiated by my grandfather, Gregorio Hairabedian, with the legal support of my mother, Doctora Luisa Hairabedian. One of the things that motivated them to prepare the case was the necessity to find new ways to deal with the tragedies of our past and look for truth and justice. Being legal professionals, they saw an opportunity to prepare a legal action for the truth of the Armenian genocide, using the right to the truth, an element of international human rights law. So in the year 2000, they applied two advanced legal principles that also form part of Argentinian law. Number one, universal jurisdiction, which allows a local court to investigate genocide and crimes against humanity in another country. And number two, the principle of non-prescription of crimes against humanity, which allows a judge to investigate instances back in history. Before they started the case, they studied the precedent of the detention of Chilean dictator Augusto Pinochet in Great Britain in 1998 by the order of the Spanish judge Baltasar Garzón. I was young, but I remember my mother and my grandfather having long meetings with specialists and leaders of Argentinian human rights organizations. When they prepared the demand and presented it to the Argentinian federal judge, they invoked their right under Argentinian law to know what happened to their ancestors and their right to know the truth. Truth trials began in my country in the context of the transition from dictatorships to democracy. When the laws granting amnesty to military government for the crimes against humanity committed during the 70s denied justice to the victim, their families used the right to the truth to require the state authorities to give information and details about the facts, circumstances, and causes related to those gross violations of human rights. In year 2000, my grandfather and my mother planned to use the obligation of the state to respect and guarantee the right to the truth to contribute to shedding light on the Armenian genocide while protecting human rights. They used the same law used by Argentinian human rights organizations to find out what happened to what we call los desaparecidos, or the missing, those forcibly made to disappear by the military government, but applied to pursue the right to know what happened to the Hairabedian family, which also disappeared in the Ottoman Empire between 1915 and 1923. This case is predicated on the fact that my grandfather, Gregorio Hairabedian, is an Argentinian citizen and has a right to the truth based on the right to mourn, because he was affected directly by the disappearance of more than 50 of his relatives, and he was denied that right which was prejudicial to him. This law is taken very seriously in Argentina. The right to the truth is also accepted as an international human right by the Office of the United Nations High Commissioners of Human Rights. The case was presented in the Federal Court of Criminal and Correctional Justice of Buenos Aires. My grandfather asked the judge specifically to develop a truth trial to investigate what happened to the members of his family killed in the genocide. We gave the judge their names and where they lived. He also stated that his intentions were only truth and justice, without any feeling of hatred or financial speculation. At first, the judge rejected the case, saying that he did not have any jurisdiction to investigate from Argentina crimes committed in Turkey at the beginning of the 20th century. My mother, as the lawyer of the case, appealed the decision, and the judge resolved to reopen the case and proceed with the investigation because the principle of universal jurisdiction was applicable. The judge also noted that the request was in the context of a truth trial with no other objective than a search for the truth. Once the case was reopened, the judge, Dr. Norberto Ollarvide, sent international rogatory letters to the governments of Turkey, US, Great Britain, Germany, Belgium, France, and Vatican City, asking them to open their historical and diplomatic archives and send official documents with details of what had occurred in the villages of Trebizond, Erzurum, Bitlis, Diyarbakir, Harput, and Sivas, where Armenians used to live under the administration of the Ottoman Empire.